Welcome to Inside Medical Malpractice. This subject fascinates everyone everywhere because it affects everyone everywhere. My name is Chris Rokosh. I'm a registered nurse, legal consultant and educator, and the president of Connect Medical Legal Experts. Medical malpractice affects patients, families, nurses, doctors, midwives, healthcare institutions, the associations that define medical standards, lawyers, and the general public. Each month, we'll be looking at malpractice issues from different perspectives, featuring honest, candid, insightful interviews by people and professionals with a wealth of information to share. Thanks for spending time with me today. Now let's dive into this fascinating subject. Today, we're going to start with an overview of the law. I'm here with lawyer Richard Halpern from Thompson Rogers Law Firm in Toronto. He's a senior lawyer with more than 30 years' experience representing injured patients across Canada. He's appeared in some of Canada's highest courts in the Superior Court of Ontario and the Ontario Court of Appeal. He has extensive experience in medical malpractice and birth injury cases and has delivered more than 70 presentations to professional groups on medical legal matters. Welcome, Richard.
Thanks, Chris.
Is there anything you'd like to know or for us to know about you before we get started?
Well, I act exclusively for patients in medical malpractice cases and primarily birth trauma cases, so children who have been injured as a result of something that went wrong at or around the time of birth. That's primarily what I do.
Thank you. That's good work that you're doing. Can you first talk to us about the basic elements that must be proven in a medical malpractice lawsuit?
Sure. A medical malpractice lawsuit is really all about holding somebody accountable for an outcome that shouldn't have happened, so some harm. And there are some basic principles that apply to what we call a negligence claim, which is what a malpractice claim is all about. Generally speaking, I think I'll talk in terms of doctors and nurses because typically those are the parties that we face in our lawsuits. I always act for the patient in these lawsuits. A patient will come to me and I have to describe to that patient what the elements of a lawsuit are in order to demonstrate that we might succeed in the case. So the elements are essentially three important things. The first one is whether or not the nurse or the doctor met the applicable standards of care. It's the first thing we have to take a look at. The second thing is what we call causation, or whether or not some sort of breach of the standard of care resulted in harm to the patient. And then if we can demonstrate both a breach of the standard of care and causation, then we ask about the extent of harm or what we call damages. So all three elements have to be proven by the patient, and we prove these things by a legal standard called a balance of probabilities, that it's more likely than not that the doctor or the nurse breached the standard of care and that it caused harm. When we look at standard of care, what we're talking about is conduct, whether it's something that the doctor or nurse did, which would be an act, or something that the nurse or doctor failed to do, which would be an omission. And we are looking to see whether or not the acts or omissions met legal standards of care. In other words, was the conduct of the nurse or doctor below what would be acceptable from somebody else in the same position that that nurse and doctor found themselves in caring for the patient. So if we can prove that the care was below standard, substandard, then we can proceed to the next step, which is to talk about causation. Now, causation is a little bit of a more difficult concept, but the idea is that but for the negligence of the party that you're suing, the harm would not have occurred. It is sometimes thought to be a necessary condition. So the act or the omission has to be a necessary condition for the harm to have occurred. And when we demonstrate that on a balance of probabilities, then we can move on to the next stage, which is determining what the patient's damages are.
Can we just back up a little bit and talk to us about how you determine whether or not the nurse or doctor met the standard of care?
The first thing that we have to do is get the underlying facts of the case. We start with our initial interview with the client to determine what the client knows about or the patient knows about what happened. And once we do that, we have to obtain all of the relevant medical records. But a lawyer cannot determine whether or not the standard of care has been met or not. That is a question for experts. So if I am looking at, say, the conduct of a nurse and whether or not she met the standard of care, I have to retain an expert in nursing with same or similar qualifications to the nurse I'm looking to criticize. That expert will then review the circumstances of the case, will review the records, will review the conduct of the nurse, will review the outcome, and that expert will then have a discussion with me about whether he or she thinks that the nurse failed to meet appropriate standards. Same thing for physicians. In many of my cases, I'm looking at the conduct of obstetricians who manage labor and delivery for mom, and in order to determine whether or not the obstetrical care met appropriate standards, I need to retain an obstetrician with similar qualifications to the obstetrician who cared for mom during labor and delivery, and get an opinion from him or her about whether or not the obstetrical care met appropriate standards. So in all of these cases, we rely very, very heavily on highly qualified experts to assist us with these cases.
And on the subject of causation, I understand that that's both a difficult legal challenge, but I think it can be a confusing concept to understand as well. Could you give a couple of examples of cases that are easy to prove causation on and cases that are challenging to prove causation?
Sure. The simple case is the sponge left in the patient after surgery. Obviously, any harm that results from something left behind in the patient's body is easy to prove on causation. It's easy to prove on standard of care, too. Doctors have checklists, nurses have checklists. They shouldn't be leaving sponges in the patient's body. But certainly from a causation standpoint, that's very clear. An example of where we might prove a breach of standard of care, but where causation is extremely challenging, would be a late diagnosis of cancer case as an example. So a patient may attend at a doctor's visit and hemoglobin is very low and the doctor doesn't follow up and it's a sign of cancer. The patient doesn't come back for 6 or 9 months or a year, and finally somebody makes a diagnosis that there's a tumor on the kidney or whatever. The problem that we have in those cases is that the outcome for that patient, had the diagnosis been made earlier, is not necessarily clear. We don't know whether we can prove in a lot of these cases that there is a difference in their health trajectory by virtue of the failure to diagnose that in time. If the disease was very advanced at the early point when it should have been diagnosed, then the prognosis presumably would have been gloomy then. And the fact that the diagnosis delayed months may not affect that prognosis. So causation is very difficult to prove. Another example that I face every day in birth trauma cases is we may be able to establish that a baby should have been delivered sooner by cesarean section or some other method, but we have very limited ways of assessing fetal well-being during labor and delivery. And to succeed in causation in a birth case, we have to prove both how the baby got hurt, the mechanism, what happened in utero that injured the baby, that's the mechanism. And we also have to prove timing. When did the baby get hurt? And it is a very complicated process in birth cases to establish the timing of injury and the mechanism of injury. Sometimes what we're left with is, after examining all of the clinical evidence, we have a window of opportunity where injury might have occurred, but narrowing or refining the timing of injury then becomes the work of multiple experts, and sometimes we have to draw a lot of inferences about what might have happened.
So thank you for that. That was a great explanation. On the subject of timing, patients who feel they may have been injured through negligence by the doctor or the nurse or something that's gone on in their healthcare course, time-wise, how quickly or how soon does a patient have to come and see you to consider launching a lawsuit?
I can speak for Ontario only, which is where I primarily practice, although I do have cases in other provinces. But in Ontario, in a medical malpractice case, we have a 2-year limitation period, and there are some qualifications to the running of that 2-year limitation period. In the event that the malpractice resulted in the death of the patient, then we have a strict 2-year limitation period that starts to run from the date of death and expires on the second anniversary of the death. What that means is that if you intend to make a claim against a doctor or a nurse, you must do so before the second anniversary of the death. That means you must issue a claim in the Ontario courts formally. With respect to situations where the patient has survived, but the patient is not under a mental disability, the limitation period runs 2 years from when you knew or you should have known of facts giving rise to the claim. So it isn't a hard 2 years from the date of the event that caused the bad outcome. But strictly speaking, because there's some uncertainty about the running of that limitation period, ideally, you always want to start your lawsuit before the second anniversary of the event and not take any chance that you might be outside the time for starting your lawsuit. With respect to children who have mental capacity, the limitation period generally does not run until 2 years after their 18th birthday, with some qualifications that I won't get into, but you can actually trigger the running of a 2-year limitation period for a child by certain means that I won't mention right now. And finally, for people who are defined as persons under disability, so people who lack the mental capacity to instruct their lawyer to manage property, it may be that the limitation period never starts to run, subject again to something you can do to trigger that. But if you have somebody who's under disability and who has not started a lawsuit for 25 years, you may still be entitled to start a lawsuit. I would caution people, obviously, memories fade and records disappear, and if it's your intention to pursue a claim, it's never in the interest of the patient to wait too long.
It must be challenging then, knowing that a lot of your work is done with birth cases. What is the average to get all the medical records? Because those don't have to be filed within a 2-year limitation period. When someone comes to you 12, 13, 14, 15, 16 years after the birth, what are the challenges that you face in moving that case forward?
Well, it's very difficult because the parties that you are going to involve in that lawsuit, the nurses, doctors, midwives, or whoever was involved in the care, their memories are long faded. They've seen thousands of patients since then. They may be retired. They may be dead. We may not find them. So that's a big problem. It makes collecting information very difficult. Records generally are retained, so we're usually not concerned about the loss of records, but even the patient's memory will fade. I think that most people should have some idea that they want to look into a medical malpractice case long before a decade or more has elapsed, and they should be more prompt in pursuing these. Some people don't pursue those claims very quickly because the medical situation is evolving. There's sometimes an enormous burden on the family looking after a disabled child, and last thing they're going to think about is contacting a lawyer. And a lawsuit in itself is a burden to the family. So you're adding a burden to somebody who's already burdened by looking after a loved one who has some profound, often disability.
As a healthcare provider myself, an obstetrical nurse for many years, and for all the other doctors and nurses who might be listening in, can you touch on the importance of their own documentation and record keeping during events when they're pulled into it anywhere from 2 to 20 years later and have to defend their care the best that they can based on a medical record with no memory of the patient?
Well, I often like to speak to doctors groups and nurses groups and tell them how they can avoid seeing me on the other side of the table. That's an important thing. And at this stage of the game, I'm also a consumer of medical care, so I'd like to see morbidity and mortality reduced, not increased. The message that I have for physicians and nurses is the importance of documentation. It's critically important. It's not only that medical and nursing standards of care require nurses and doctors to keep copious records. That goes without saying. The importance of those records is not the records themselves, but for other purposes, including demonstrating that their conduct at the time that they were treating the patient met appropriate standards. And you can only prove that through records, through careful, detailed records. The best defense that any nurse and doctor has is a good medical record. Put it the other way, the corollary is a bad medical record often is something that will attract liability for the nurse and the doctor. They won't have a memory. We will know that there's a bad outcome. The missing documentation may be directly relevant to the bad outcome, and an inference that is against the interest of the doctor or nurse may be drawn by the court by virtue of the fact that important clinical data is missing. So my message to doctors and nurses first is to make contemporaneous notes if they can. If they're not contemporaneous, do them as soon after the event as you possibly can. It's always better to make a note before you know the bad outcome because you'll be more credible. It's also essential in your communication with your colleagues. Most medical care is a team approach to care. Usually nurses on the front line. And the best thing that you can do to protect yourself from liability is to communicate well with your colleagues. So I tell nurses and doctors, obviously, to keep careful notes about that. And then if the unfortunate thing happens and you become embroiled in a lawsuit later on, good notes are going to be your best friend for defending that lawsuit.
Thank you. Another question. Research shows that there are literally hundreds of thousands of serious medical errors in Canada every year, and statistically less than 1,000 of those serious errors or adverse events ever turn into lawsuits. How can you account for that?
There are a lot of reasons why we don't see a lot of lawsuits in Canada, and it's unlike the United States where there are exponentially more lawsuits. Many of the errors that occur in Canadian hospitals each year are medication errors. Many of them do not result in serious long-term harm, so patients don't pursue them. Another reason is that there are, I find, many occasions where the patient actually isn't aware that an adverse outcome was the result of somebody else's neglect, and that's a big problem. Another factor is that medical malpractice lawsuits are quite expensive to pursue. They are complex, they are protracted litigation, and you have to have an economic justification for pursuing a medical malpractice lawsuit. So the damages often in these cases drive the decision whether or not to pursue the case on behalf of the lawyer acting for the patient and the patient themselves. I don't certainly encourage people to get involved in litigation unless at the end of the day there's an outcome that's going to be favorable to them. It's adding insult to injury if you get your client involved in litigation where there isn't a serious benefit to be had by the patient. Another factor in medical malpractice lawsuits is that in some of these cases, the outcome is not clear. The cause for the outcome is not clear. It may be due to a pre-existing disease process. It may have been due to neglect. The fact that there's a bad outcome does not mean that a nurse or a doctor made a mistake. And some people mistakenly think that because you've had a bad outcome, or what we call an adverse event, that somehow somebody is going to be responsible or accountable for that, and that's just not the case. Bad outcomes don't make doctors and nurses accountable for the harm unless that bad outcome can be attributed to substandard care and you can prove causation. It's often not clear in medical malpractice cases whether you can prove causation. Some of them are extremely complex. And in order to pursue and to prove a medical malpractice case, you really need, on behalf of the patient, extremely skilled lawyers and experts to tease out the relevant medical issues, the issues of proof, to establish proof, and then to advocate for that patient. Another factor that affects medical malpractice cases is that all of the doctors, or most of the doctors in Canada, are defended by a single group, the Canadian Medical Protective Association, the CMPA. And the CMPA is very diligent in the defense of doctors. They provide excellent protection for doctors. And as a result, it makes it challenging for the patient to pursue a medical malpractice lawsuit. And that challenge, not everybody's up to that challenge. So you have to be careful about which cases you pursue.
You mentioned that medical malpractice cases are very expensive to pursue. Is it expensive for the patient?
It is generally at a cost to the patient, not necessarily in money out of pocket, although there can be exposure to the patient for a medical malpractice case. Generally speaking, because these cases are so expensive, the lawyers handling these cases must take the case on based on a contingency fee agreement. And a contingency fee agreement is where the lawyer does not get paid until the end of the case and only gets paid in the event that the case is successful. So the patient would not be responsible in that scenario for the legal fees from his or her own lawyer. On the other hand, in Canada, we have cost consequences for parties involved in litigation who do not win their case. So if the patient pursues a lawsuit against a doctor or a nurse or a hospital, and at the end of the case is not successful, strictly speaking, the patient may be responsible for some of the legal expenses incurred by the doctor, the nurse, or the hospital in defending the case. That can be substantial. It is often the case that defendants in these lawsuits do not pursue costs against unsuccessful parties, but they may well. It's happened, and it can happen. And therefore, patients ought to be well represented and well informed before they pursue litigation, given the fact that they may be exposed to a cost award against them, often in the hundreds of thousands of dollars, for a successful defense of the case. Must be very careful about that.
That would be very stressful all the way around, I would imagine, for everybody. I appreciate very much that you said that it's expensive and it not necessarily monetarily expensive, the toll. I think it's fair to say the toll this takes on everyone, on healthcare, on patients, their families, on the healthcare institutions, our social systems that support the injured patient. It takes a huge toll. Time-wise, once a lawsuit is commenced, what time frame are people looking at to the resolution of some sort, whether it's settlement or dismissal or trial?
Again, depends on the case. The time it takes to prosecute a case largely depends on the nature of the case and when you're able to establish the extent of the damages. I'll give you an example. If it's a birth trauma case where the baby has suffered brain injury, has cerebral palsy, and learning problems, motor problems, we're not in a position to assess the extent of the loss for that baby and settle a case until we have some idea about the baby's prognosis. Will the patient ever return to work? What kind of care will they need? Will they live independently? Do they need assistance for living? Do they need special housing? Do they need special transportation? Do they need different therapies, physiotherapy, occupational therapy, and other therapies? So in the case of children with cerebral palsy, or children generally who have serious injury, our medical experts are not in a position to prognosticate about the future, often until the child is 5 or 6 or 7 years of age. As a result, we as lawyers must be very, very careful not to attempt to assess or settle these cases prematurely, because once you settle a case, it's settled once and for all. There's no coming back and getting more money should circumstances change. So a good lawyer will be very careful to ensure that there is a prognosis from highly qualified medical practitioners such that we are able to make reasonable predictions about the future. We will then engage an economist or an actuary who will calculate how much money we need at that time to generate an annual amount of money for the child that will meet the child's needs throughout the child's life. But often that is 6 or 7 years to get that done. In other cases, if in the case of death, we can evaluate those cases much sooner. They can reasonably resolve in 3 or 4 years. Very few cases settle before the 5th year.
That's a long time.
Well, courts are busy too.
Yeah.
The thing about malpractice cases is that because they're so complex, they take a long time to try in the event that you have to go to trial. The courts have a limited capacity to try long cases, and most of these are long cases. They can exceed 30 days of trial time. So you can imagine that the court resources are also strained by these cases. But I think it's the responsibility of the lawyers acting for patients to push these cases on just as quickly as they can, to marshal all the resources they need to prove the claim, get the appropriate experts lined up, do it as quickly as you can, demonstrate to the other side that your case has merit, that you're being reasonable, and you can facilitate a settlement long before you get to trial in those cases.
What percentage of the cases that you work on settle versus going to trial?
I can only speak from my personal experience. My personal experience is not the experience of malpractice cases out there generally. There are a lot of malpractice cases out there that end up being abandoned, and I mean a lot. For me, the vast majority of cases do settle. We prepare them in such a way that it promotes settlement. We try not to pursue cases that aren't truly meritorious. We don't pursue cases that aren't truly meritorious. Doesn't mean that a case can't be lost. There's always two sides to this coin. But generally speaking, we prepare for war to make the best peace in these cases. And because we prepare in that way, that facilitates settlement. Some of our cases settle late in the day, perhaps on the steps of the courtroom, but most of them do settle.
Thank you. That's great information. I think the topic of what makes a case meritorious or not is the subject of a whole nother conversation that we can have in the very near future. For today, I think that's a great overview of the the legal perspective of medical malpractice lawsuits. And I want to thank you very much for being here.
Thanks, Chris.